So why have you paid no support at all if you're getting $15.88 a month?
Because I'm trying to pay all my bills off.
I know, but you have 2 children that need food, clothing, and shelter.
After I finish paying all my bills and when my children come home.
So I'm going to be blunt. I'm not going to sugarcoat it. So your wife makes 50 grand and your household expenses at your marital home use up her whole 50 grand of income and your $15.88 a month and 60% VA disability. You have nothing left over for your 2 14-year-old twin daughters to help them with food, clothing, shelter.
She also has an autistic child, stepson, and a daughter.
All right. Good morning. I am referee Brian Nicholas with the Macomb County Family Court. We are here then today on plaintiff's motion to enforce child support payments to bring arrearages current for modification of parenting time and other miscellaneous relief. Counsel, if you would like to proceed.
Thank you, Your Honor. And I know you've already read my motion, so I'm not going to go through the whole thing, just basically the highlights. But these folks were divorced August 4th, 2022, so just a little over a year ago. The fall of 2022, Mr. Ortega gets engaged. He gets married February of 2023. The judgment provides that he has 115 overnights with the kids. But during this last year, he's only exercised 54 overnights with the kids. My client keeps a very meticulous calendar and schedule because we've got twins that are 14 and very, very active, involved in all kinds of different things. So my client really needs, and my client works full time, so she needs to make sure that she's very, very organized. So mid-February, I guess a honeymoon, he goes on with his new wife and gave up his winter break. He says he asked for the kids to go, but I don't know that to be the case from my client. And then boom, out of nowhere, he's making 50, 60 grand. March 24th, 2023, he resigns from his job. He did not notify my client that he resigned from his job. And he did not notify my client about the fact that the children would not have any health insurance coverage until the very night that the insurance ended at midnight that night. So then he says, well, I'll put them on Medicare or Medicaid. My client reluctantly, because in the judgment, it specifically provides that he's to provide health insurance. My client says, no, I'm going to put them on my health insurance because they need, for all their extracurriculars that they participate in through school, they need to show that they have, valid medical insurance and that there isn't a lapse in coverage. And when it's going to expire at midnight, there's going to be a lapse. So that's just in response to Mr.'s claim that my client was thrilled to death to put the kids on medical insurance. There's over a $6,000 arrearage on this matter. Okay. We get some letter dated May of 2023 attached to counsel's answer. May 24th, 2023, the patient has post-traumatic stress disorder, migraine, something or other, degenerative disc disease, neck and cervical, blah, blah. I mean, honestly, this person was capable and able to work all this time before. Now we just suddenly can't. So we get remarried, that wife's working, but nobody's paying anything to support these 2 children, these 14-year-olds that my client is supporting 100% on her own. And I don't think that the defendant even really cares about that, how that happens. He moves to St. Clair. My client lives in Sterling Heights. She absolutely will not agree to participate in driving while she's working full-time, taking the kids to all their extracurriculars. Literally, the judgment provides, the non-custodial parent provides the transportation. He's to provide the transportation. Your Honor, I go through all of these different incidents and events that occur at the house with he and his new wife. There's a domestic violence that occurs that the kids see, the kids witness. Okay. I mean, this is a very, very difficult situation. And Your Honor, my client's new wife is texting the children, okay, about your mom filed court papers and that you don't want to see your dad anymore, something to that effect. So bloody inappropriate. This is adult matter. The children shouldn't be involved in this at all, from defendant or his wife or my client. My client shouldn't say anything to the kids either. This is an adult court matter and not something that the kids should be. They've been exposed enough in this short-term relationship with dad's new wife. They've been exposed to plenty enough. Also, his new wife texting my client at 3:05 in the morning about it. Come on, let's all grow up, be adults. Let's do what's best for the children. I think with all of these various and sundry alleged conditions that Mr. Ortega has, perhaps there should be a complete psychological done in addition. This domestic violence in the house, this is scary. And I got two 14-year-old girls that are very involved in extracurricular. I think, are they right now running cross country?
Cross country, and then both do cross country and one does color guard.
Okay.
And one is student council and one is in CSI.
Okay. So they're good kids. They're getting good grades. They're and I mean, the judgment provided when dad was working that dad was going to give his notice to my client 60 days in advance and that he would have 2 overnights a week. Well, I mean, now it's willy-nilly. He lives that far away. It shouldn't be overnights during the week. That's an hour, according to his answer, an hour drive. The girl shouldn't be forced to get up at that time of the morning to get to school on time. So
let me ask this question of Miss Vega. So Miss Vega, you counted up over the last year, he only did 50 some overnights, you assert. Was that on weekends? Was that just random? How did those 50 some days happen? Were they weekends during the week? How was it, just randomly, or was there a schedule?
Those were the scheduled times that were dictated by his schedule through work. Those did not include the times that they were sick or they had conflicting schedules, like with their extracurricular. These were the times that he said that he could take them. The times that he missed were the times that he had an injury to an assault that he had at work. He had an illness. His household had an illness. He had transportation issues because they only have one car, or he had childcare issues because he watches his 2 stepchildren and there weren't enough seats in the car for all 4 of them. And he couldn't get our 2 girls, our children, back and forth to their activities. So that's how the 54 nights came to be.
So have the nights increased after this assault? When was this assault and the downtime for injuries associated with this assault?
The assault happened on
August 16th.
Yes, and he's had 1 overnight with them since then.
And you're talking August 16th of 2023 or 22?
23.
Okay, so he was behind in overnights prior to August. Yes. When this recent assault. So the 50 some overnights, that's inclusive of last August all the way till now.
Yes, sir.
So that 52 is pretty much comprised before this injury.
Yes, it's 54 overnights is a snapshot from August 6th of 2022 to current date of this year of August 2023.
Okay, so that was before this injury happened and the none thereafter.
Correct, sir.
Okay, and counsel, I didn't mean to cut you off here. Anything else, counsel, before I hear the response?
I just honestly think if we're doing what we're supposed to be doing in terms of putting the children's best interest first, that our parenting time right now be non-overnight, that child support be brought current, because I don't know about you, takes a lot of money to raise 2 14-year-old kids on your own. Takes a lot of money. And there's a current charging support order that literally Mr. Ortega's just, thumbing his nose at. Didn't do anything at all. And his wife isn't doing anything toward trying to pay down this support arrearage. I just, and if he's trying to qualify for disability, well, until we're qualified, we still have we still have an ongoing support obligation that needs to be complied with. And if he did qualify for disability, then the children would get some type of benefit, but they have
All right.
zero benefit. And my client's looking to be reimbursed for the medical insurance. Again, he just stops doing. He doesn't go to the court and say,
Okay,
this
I
is
got
my
you.
responsibility and I'm doing
All right.
nothing.
All right,
And-
I got the argument. All right, counsel, your response to everything?
Yes. Good morning, Your Honor. Your Honor, as it relates to the parenting time, my client obviously acknowledges that he lives an hour away. And oftentimes when he does have the children on the weekend, he does voluntarily bring them back Sunday night instead of Monday so that they don't have to wake up at 4 a.m. to get to school on time. So I know that that does account for some of his parenting time days or overnights that have, would have added up to his 115 overnights. There's been also sometimes that my client, does claim that his parenting time has been denied by plaintiff due to the children being involved in extracurriculars. He hasn't filed a motion for makeup parenting time. I'm not arguing that he at this time about makeup parenting time. However, I want the court to know that my client is not just not seeing the children because he doesn't want to be involved in their lives. Oftentimes, if he gives up an overnight, it's to accommodate or be more convenient for the children and their travel so that he doesn't have to travel back and forth with them at early hours of the morning to get them to school or other activities. We would also, Your Honor, as it relates to his job, he was employed with MDOC. He did resign back in March. He has had multiple hospitalizations, including one last week. He does suffer from PTSD. He's 60% disabled through the VA. He has applied for 100% disability through the VA. We have not received a decision on that, whether or not that's been approved. Obviously, there is a charging order in place. Child support is accruing and there is an arrearage. I would ask for the court to refer this issue to friend of the court, set up a payment plan, or refer this for further investigation. Hopefully at some point soon, we will have an answer as it relates to his disability. But until then, I understand something has to be done. The issue, Your Honor, as it relates to the parenting time, I'm just going to go back to that real quick. I know opposing counsel is arguing that his parenting time should either be suspended or no overnights. The issue that happened with the domestic violence, there's been no CPS investigation. There's no law enforcement interaction going on with that. In addition, my client voluntarily, to try to understand and be proactive about what's happening, he underwent a substance use evaluation on September 12th. He has a follow-up this coming week where they will make a plan of treatment if one's appropriate. Him and his wife also have signed up for marriage counseling, which is to start, I believe, this week as well. And then he also signed himself up for a mental health evaluation to determine a plan of care as it relates to that and his current PTSD issues. He does get benefits from the VA. So all of those appointments and providers are through the VA. Once those are available, those reports and plan of treatment, we will gladly, share those with the court. And we're proposing that my client complete those and follow all recommended plan of care. That I think, at least from what I'm hearing, is a lot of these issues that is going on between my client and his current wife, or the alleged issues. I think that him entering into these treatment programs hopefully will start to derail some of these issues that are going on.
And
Lastly,
why
Your
is
Honor,
there why is there a substance abuse evaluation?
because there's allegations that at least the most recent incident was involved with alcohol. I think mostly on the part of my client's current wife. But to be transparent, my client also signed up to do a substance use evaluation as well. I am awaiting those recommendations. I think, and Mr. Ortega could correct me, but I think that follow-up appointment is this week to determine a future plan of care.
Okay, let me ask this. And how long was Mr. Ortega? And Mr. Ortega, you can answer too, but you have counsel, so that's why I'm talking to counsel, but I don't mean to act like you or Ms. Vega are not here. So how long was Mr. Ortega with the Michigan Department of Corrections?
About 3 years, Your Honor.
Okay, so let me ask, why would you quit rather than do you have long-term disability or short-term disability through your employment at MDOC?
For Your Honor, for several months, my Dr. Linda Coulter was telling me that they were recommending that due to my health, I should quit. Only reason why
Right. But the point I'm making is, why would you quit rather than submit medical documentation to your employer, MDOC, and go on long-term disability based on medical disability provided through your employer? Why would you? Because when you quit, you don't avail yourself of any disability through your employer if it's available, and you then don't get unemployment. Because unemployment, if you voluntarily quit, you don't qualify for unemployment. So if you're disabled because of PTSD or stress that's exacerbated by work, why wouldn't you try to get workman's comp, or why wouldn't you try to utilize your short-term disability? So workman's comp would be attached to something at work. So I get if you're saying my medical problems are from the military and stuff,
Yep.
They're not from work, I'm not going to qualify for workman's comp, but you can qualify for short-term disability or FMLA because of medical issues that make it so you can't work. I guess I'm wondering, why did you have any kind of disability policy long-term or short provided by MDOC? And if not, why wouldn't you apply for FMLA or a leave based on medical problems?
Your Honor, I did have FMLA, and at the time I resigned, I extinguished all my FMLA hours. While I was working at MDOC, I was roughly getting paychecks of $100 because I was paying child support. $50.
Okay, so you had some kind of disability. Correct me if I'm wrong. I'm listening.
Yeah.
And you depleted all your FMLA, and they said we can no longer accommodate you. You've utilized all of the accommodation we can provide to you based on FMLA. Does that sound right or wrong?
Not correctly. I had an episode at work, and at the moment, it was best for me to resign. My blood pressure was going high, etc., and I resigned.
But why wouldn't you just utilize more FMLA? Why would you suddenly resign?
Didn't have no more FMLA hours. At the time, I didn't. At SSD, I was in the military. SSD, non-civilian benefits is stuff I'm still learning.
Have you applied for Social Security disability?
No, I'm waiting to see what happens with my VA disability.
Is the VA disability greater than the SSD through the federal government through SSD?
If I get 100%, if I get 100% VA disability, I'll roughly get
I would say if you get 100%, well, you'll get $3,900 a month. Is that about right, or am I wrong?
About 4,000.
Yeah, I was gonna say it's about $3,900,
Yeah.
and that's probably more than SSD. Any ideal when they're going to make this determination? What's your 60% getting you? You're 60% disabled. What does that get?
My 60% is $1,588.
$1,588. So why have you paid no support at all if you're getting $1,588 a month?
Because I'm trying to pay all my bills off.
I know, but you have 2 children that need food, clothing, and shelter.
After I finish paying all my bills, and when my children come over to my house, entertaining them, buying them, and giving them everything they need.
Well, let me ask this: is your current spouse employed?
Yes, she is.
Okay, and what kind of income does she earn?
About 50,000, 60,000. Her paycheck is.
So you guys have so much, and I'm not saying this to be mean or disrespectful, but I'm going to be blunt. This is a court of law. So I'm going to be blunt. I'm not going to sugarcoat it. So your wife makes 50 grand, and your household expenses at your marital home use up her whole 50 grand of income, and your 1,588 a month and 60% VA disability. You have nothing left over for your 2 14-year-old twin daughters to help them with food, clothing, shelter.
She also has an autistic stepson and a daughter.
Yeah, but your children are getting zero. You haven't paid anything since May, but you have almost $1,600 a month coming in, and a wife who's making 50 grand. You couldn't even come up with 100, 200, or any attempt to pay at all during in the last several months.
Every time I'm getting ready to make a payment, something, for example, this motion that got filed, I was about to give her $3,500.
Well, why don't you not pay it? What are you using your $1,600 a month for? You're almost $1,600. What are you paying with that?
Paying my bills.
Okay, but
My car note. And
isn't
my
it more
credit card.
important that your 14-year-old daughters have food on the table than if you pay your credit card payment one month or get behind on some other bill?
Every weekend when my daughters come and see me, the weekend they do come see me versus minus the days I have COVID or the.
Why have you waited till they file a motion to ask for a modification of support? Why didn't you ask when you stopped paying back in May? Why haven't you brought this to the court's attention?
I contacted the front of the court shortly after I resigned, informed them that I resigned due to medical reasons. I sent them a copy.
And they told you have to file a motion, probably, right?
They told me how to file a motion. I got no assistance on how to file it. They told me that I need to come back to them by mid-September, end of September.
Okay.
So
what is Miss
Excuse me, Your
Vega?
Honor,
What do
I'm
you?
having a hard time understanding Mr. Ortega.
Okay, I can. Are you guys? I can hear him. Okay, can everybody else? I can understand him. So, Miss Vega, what do you do? Okay, I can hear him. Okay, but I'm sorry if you guys. So, Miss Vega, what do you do for work?
I'm an administrative assistant for Utica Community Schools.
And you have a 2-income household or no significant other spouse?
I have no.
Okay, so you are the sole support of your household. So when you get nothing, you have to support your daughters and your son from another relationship. I hear another. Is that correct?
I only have the 2 twins. I don't have any other children.
Okay. So, sir, did you not say?
A 5-year-old and a 7-year-old, the new wife.
Oh, okay. I got you. Okay. All right. And ma'am, what kind of income do you earn?
I earn about $40,000 a year.
All right. So Mr. Vega, you understand where I'm going with this? She's a single parent making 40 grand. You have 1,600 a month coming in, which is upwards of 23,000 a year, and your wife is employed, and her children are her responsibility, is not yours. I would expect some kind of money to come out of your $1,600 a month. If you can't pay the $1,100, I may understand that, but paying zero doesn't. I mean, that leaves it up to Ms. Vega as a single mother to pay all these bills. That doesn't work. All right, Ms. Bomarito, anything else you want to add?
Your Honor, the only thing that I wanted to bring up was just that the parenting time, obviously in the judgment of divorce, the parenting time was based on my client's work schedule and days that he's off. I guess at this time, I'm first proposing that that the parties communicate through app close. I think Ms. Finazzo was proposing that as well. But also, in addition to that, the schedule, my client lives an hour away from the children where they go to school. So I know that is something that is of concern for all the parties. So
I'm gonna change their schedule today, guys, just so you know.
Okay. And I think my client, I guess, would propose an alternating schedule so that the children still have weekends with mom as well. Maybe an alternating weekend schedule or a Thursday, Friday, so that there's limited, time for them to have to travel to school.
I would in fact agree with that.
Except, Your Honor,
so guys,
go
ahead, Ms. Finazzo.
Not overnights during the weekday when he lives an hour away.
Okay, I got you. I got you guys. All right, so guys, I'm going to make a recommendation, a temporary order of the court. You both have 21 days to object. That is your right under the law. At an objection hearing, the Honorable Terry Lynn Dennings may uphold my order or change all or part of it. Again, I do not get upset. The judge doesn't get upset if either one of you objects, because it is your right. There's no cost to object. That, however, does not cover your personal attorney fees. All right, so my recommendation is going to be as follows. 1, on a temporary basis. And let me just get defendant's parenting time is modified to the 16th Circuit reasonable parenting time schedule, with defendant providing the transportation to effectuate his parenting time. That is an every other weekend schedule from Friday to Sunday. I'm going to eliminate the midweek. It doesn't sound like that's doable. The midweek dinner parenting time is eliminated, because Mr. Ortega, I take it you're not going to drive to exercise 2 hours at dinner on Wednesdays. Would that sounds logistically not doable? Is that correct?
If it is to see my kids, I'll do anything.
So you want to drive there and go to dinner with them once a week on Wednesdays?
Yeah.
Okay, well, I'll leave it in there. I'm just going to indicate, it's okay. I'm not going to eliminate the midweek, but I'm going to indicate that defendant shall contact plaintiff on Tuesday of whether or not he chooses to exercise his Wednesday dinner. So, sir, you got to let her know a day in advance if you're planning to do dinner. So she has a heads up and the girls have a heads up if you're going to do the dinner or not. Obviously, that's not a lot of, you're not going to be able to drive there and drive back home. You're going to have to take them out to dinner somewhere near Ms. Vegas because you don't have time to get there and back. But I'll leave it in there if you want it. I'm going to put a 2. Defendant shall pay $750 towards his child support arrearages immediately. So, sir, you've had since May, you get $1,600 a month. You need to make a payment towards that arrearage that's accumulated. I'm trying to be reasonable with that payment. You got to pay something. Should defendant be asserting disability? He should provide verification from from his treating physician, at minimum on doctor's letterhead, indicating the exact nature of his illness or illnesses, and any restrictions on his ability to work. So the exhibits, I appreciate them attached to the response that you're getting 60% VA disability in the list that you're asserting, but that is not from a treating physician. I need verification. Same thing that anyone else is going to want for disability, I want as well. And just asking for it and listing off things isn't going to do it. I need some kind of, me or the referee who does this hearing is going to need more detail, and you can talk to your counsel about that. Is there anything else, guys, that you need me to address with this order that I failed to address?
Yes, Your Honor. I want a date, please, that $750 has to be paid by.
It's, I would say it's forthwith, immediately.
Can I have it
It's immediately.
forthwith is different to all, can I have by September 22nd?
Okay,
Can I
I
have it-
will put, that's fine. I'll put by, today's the 18th. I'll put by end of the day. We'll switch it to, shall pay $750 by end of the day, Friday, September 22nd, 2023.
Thank you, Your Honor. And is there
Okay.
an ongoing monthly support amount that's being paid?
Well,
While
there's
we're
that,
waiting for the evidence hearing?
well, I mean, it's charging $1,100 a month. This is what I always say. And this is the point I was making, Mr. Ortega. Paying something is better than nothing. Paying something shows an attempt to recognize an obligation and the need of your children. Paying zero and saying, well, I have my own expenses with my spouse isn't overly impressive to the court. No offense. Paying something is better than nothing. So I would suggest something be paid rather than zero.